after the budget ratification meeting. What are the advantages and disadvantages of this approach? Are there important reasons to keep them separate? For example, should we hold the annual meeting in January at the beginning of the new fiscal year? The short answer to the question is that the statute requires that there be one membership meeting per year under 6490-445, Section 1A. I would want to remind you that the statute applies to all communities, whatever formed in whatever form. So whether the WUCIOA provision for the meeting requirement applies to all communities. The statute does not specify when the meeting must take place, but keep in mind that your governing documents might require you to hold your meeting on a specific date, and that would certainly prevail in this instance. However, if there's no mention in your governing documents, you can have that meeting any time that you like. Now, separately, WUCIOA under 6490, Section 525, the budget ratification provision, requires that you ratify any new budget at a meeting of the association. So it's perfectly fine to have your annual meeting and your budget ratification meeting concurrently or sequentially on the same day. And there's no particular reason that we can think of that you must or should have them separate. But do note that the budget ratification process does not require a quorum. But for an association to conduct any business typical of an annual meeting, there must be a quorum. So there's different requirements for quorum for each of those two types of meetings. I will add a few comments here. Some communities we see like to combine the two meetings because they believe they're going to have better attendance. Some communities feel oppositely, and they may choose to separate those two meetings, hoping not to get the attendance required if they're concerned about the budget being rejected. Some communities conduct their annual meeting and budget ratification on specific dates. For example, on a holiday like Memorial Day or Labor Day, because they believe they will have the most owners in attendance at that time. Another comment would be that some communities prefer to have their elections after the end of the fiscal year has concluded, and they have a full view of what occurred that year. So those are some other comments, but again, to repeat here, other than to comply with any requirements that are in your governing documents about when you should be having your annual meeting or your budget ratification meeting, then we have no preference or recommendation to you as to whether or not there's no preference or particular reason that you have to have them separate or together. Ken, did you have any comments to add?
No, I think you did a good job. So next question is RCW 6490-455, which is the voting statute, states that at a meeting of owners, the following requirements apply, unless the declaration or bylaws provide otherwise, except as provided in subsection 9. Subsection 9 is the secret ballot section. Unit owners or their proxy holders may vote by voice vote, show of hands, standing, written ballot, or any other method authorized at the meeting. So then the question writer says, we are an old act condominium. Do 6490-445, which is the meeting section, and 455, the voting section, apply to us? And the answer is that the meeting section applies now. Every community in the state is required to follow the meeting section in 445, but the voting section of WUCIOA does not apply to old act condominiums. But there's also a very similar section which was added for voting to all of the other 3 community association statutes, which will apply. Okay. So as far as the voting rules, section 6432-280 would apply to you, and it contains almost exactly the same wording about the different methods of voting at a meeting. Okay. The next subpart of the question is, will mailed ballots be required for votes, including new board members? Well, the short answer is no. There's nothing in the meeting section which requires mailed ballots. They are an option under your existing statute and under UKIOA, but and they are an option unless the governing documents require or prohibit mailed ballots, in which case the decision is left up to the board. So the section of the statute, which is subsection 6 in 32-280, states that an association may conduct a vote without a meeting. And that event, it lists how that would have to be done. Okay? But it is an optional thing for the association. Next subpart of the question. If we have a secret vote in a Zoom meeting by sending each member to a breakout room with the property manager, will that constitute a secret ballot? And I'm going to say the short answer is that there is no secret ballot requirement for your community today because the secret ballot provision does not apply to old Act condos until 2028. Okay? The answer to the question is, can you conduct a vote by having each of the members talk to the property manager? I'm going to say I don't know for sure. One of the problems with that is that it does not produce a record that could be audited easily. And so it may be possible to create a voting method which would have each person tell their vote to a third party like the manager. And I guess the manager could then document the results. So we could probably find a way to make that work. And part of the question would really be, is anyone going to challenge the vote and the procedure that you've used? Because if no one's challenging it, then you can pretty much vote in any manner that you want to. The section of UKIOA, which is different from the other three statutes, is what was added, I believe, in 2025, which is the section requiring secret ballots for elections and for amendments to the governing documents. I don't know why the legislature amended UKIOA and did not amend the others to require secret ballots, but it has started to become a problem for some of our communities because we have clients where an owner is demanding to see how everybody voted after the fact, and the statute does not require that this ballots be kept secret. I guess the next subsection, does it allow those holding proxies to vote on behalf of those who have given them a proxy? And the short answer is yes. That's the whole purpose of a proxy, is to allow somebody to vote on behalf of an owner who cannot attend. Okay? And they would have the same voting rights unless the proxy restricted how the voting is to be done by the proxy holder. So a proxy can be a directed proxy, which actually states how the vote is supposed to be cast. It could be a proxy that limits the topics on which the proxy holder can vote. So they may be allowed to vote on the budget, but not to vote on an election. So it really depends. The owner who writes the proxy is who gets to decide what rights the proxy holder has. But at a meeting, the proxy holder has all of the same voting opportunities as the owner would have if the owner had showed up themselves. Okay. I think the last subsection is, if yes, meaning the proxy holders get to vote, do those who give proxy need to know in advance who the candidates for board members are? So my short answer would be no. A proxy holder who attends the meeting for an owner would have no entitlement to information different than the owners who attend in person. And an owner who gives a proxy would have no entitlement to information not distributed to all other owners. So I'm not exactly sure what the intent of that last subsection of the question was, but we are seeing a lot more communities where they are trying to conduct their elections by ballots that they've mailed out in advance. And the statutes do allow for ballots to be mailed out in advance. But if the governing documents also allow for nominations from the floor at the annual meeting, you still would have people who could be wanting to be elected and their name was not distributed to the owners with that ballot. Now, Ukiah was amended so that when you send a ballot out like that in advance, you're now required to leave a blank line for a write-in vote, but that's not going to change the issue of people being asked to vote before they know every person who may want to be elected. So that was a long answer. Do you want to add anything, Tima?
I don't think so, Ken. Our third question here, at the risk of sounding glib and oversimplifying, why would we not rewrite all of our CCR declarations with the single statement, please refer to WCIA RCW 6490? So I believe what you mean here is in reference to the future changes coming up on January 1st, 2028, in which WCIA will replace all of the existing statutes and be the one statute that applies to all communities. So the short answer is that the statement is oversimplified in that it would not address simply writing that into your governing documents would not address or incorporate all of the requirements for your CCRs. So to elaborate on that, WCIA, yes, does go into effect January 1, 2028, regardless of whether or not an association has actively adopted WCIA, and will trump any provision in their governing documents that conflict with the statute, but only if it conflicts. So for some parts of your CCRs, there are very specific mandatory provisions required to be included in your CCRs. For example, those that are related to the collections of delinquent fines, assessments. These provisions specify how meetings are to be conducted as well. So those are two examples. Other parts of the CCRs, there are specific, the statute actually allows a broad range of options for which each individual governing document has to clarify within their governing document. So, for example, the boundaries of the unit, those are specific. The insurance requirements for the interior of the units, those are specific and need to be included in your CCRs. Restrictions on use, that's another specific requirement. Another one would be whether or not you allow proxies or voting by mail. The statute says unless it's limited by your governing documents. So another aspect would be quorum sizes. What are your board sizes requirements? The percentage required to amend documents. The statute says anything between 67% and 90%. So your governing documents need to be more specific in those areas. And simply writing that WCIA is going to take care of any conflicts, it doesn't address what are your requirements for your governing documents. So, to conclude my comments here, I would just say, if the statute doesn't have a fixed requirement for something, you must include in your CCRs that information in order to determine your owner's rights and obligations. And you must, for example, have bylaws or any other type of organizational documents to clarify how your community makes decisions and governs itself. So simply referring to WCIA as your overriding provisions for your governing documents won't cover all of those specifics. Ken, did you want to add anything more?
Sure. Ukiah, replaces things like the Home Association Act and the Condo Act, which basically started putting limits on private land use agreements, which have existed for 100 years, because there have been homeowner associations and agreements amongst groups of owners on how to regulate the use of their property, dating back into the 20s and 30s of last century. So when the HOA Act came out in 1995, it was to impose some, regulations on those organizations to create some uniformity and predictability for landowners. UKIOA is taking that even further and trying to create more uniformity and some restrictions on associations doing things which the legislature believes might abuse the authority and power of the community. So the sections we've talked about for board meetings and being open and transparent, those are the legislature imposing requirements on how the communities govern themselves. And it's true, you don't really have a lot of options with that because the legislature has set minimum standards now. But even within that one section, the legislature did leave opportunities for you to edit that. So the section on proxies in that same section, you're not required to allow proxy voting. You can prohibit proxy voting if you want to. You can prohibit voting by mail if you want to. So there are many sections of UKIOA that will start with a sentence in effect saying, unless restricted or otherwise provided in the governing documents, in which case you can edit that section of the statute however you want. Then there are other sections of UKIOA where it might say something like, notwithstanding anything in the bylaws or the CC&Rs, the association must do something. And that would be an example where you could just say, refer to this section. And it might be that the notice provision of UKIOA is one where a single sentence which just says notice shall be provided as required in the RCW 64.90 is good enough. And we have a lot of clients where they look at the powers of the association, which is 2 or 3 pages long if you copy all the powers out of the statute. And they will just say, well, we'll just adopt all of the powers allowed by the statute. But we also have clients that will go through and pick and choose some of the individual powers that the statute authorizes and delete them because they don't want the association to have the power to do something specific. So like they may not want to allow a merger, or they may not want to allow for participation in an LID with the county. So I'll say it is not as simple as just adopt all of UKIOA. And that's why even the most basic, I'll say UKIOA compliant declaration ends up importing a significant amount of information from your old documents into a new document that copies the statutory requirements of UKIOA. Okay. Next question. Has any consideration been given to make developers of common interest communities place all the declarant transition provisions in an addendum to the declaration instead of muddying up the body of the CC&Rs with verbiage that will become irrelevant once control has been turned over to the HOA's elected board? The statements live on as confusing, irrelevant, space-consuming. It seems like it'd be cleaner. So, of course, what we don't know is why the legislature would set up certain things the way they do. The short answer is that there's no statutory restriction against putting all the declarants transitional provisions into an addendum, which you could disregard, but it'll still be part of the recorded document, and it'll have to be printed out, and it still remains in those documents until or unless you actually record a new document to delete them. And then when you record the new document to delete them, you just added more documents to be printed every time a title report is done. One of the things that has to happen is that any property right has to be recorded with the county. So all the developers' detail on what they are allowed to do prior to sale of the units has to be recorded with the county. Whether it's in an addendum or not, I don't really have an opinion. There was a while where an attorney up in Bellingham was writing lengthy addendums, including all the the requirements for insurance and damage and destruction because he felt like they were cluttering up the body of the document that his clients were using. And I'll say, I think it made things more confusing because people would have to check two sections of the document to know whether or not they'd addressed a particular issue, like whether or not an owner was paying the deductible for insurance. Anything you want to add, Tima?
I don't think so. Um, I will move on to the next question. If an owner or a non-owner performs landscaping on the condominium property without informing and/or any consent from the board, is the HOA liable for injury to that performing owner or non-owner? So the short answer is not that short, and it's our favorite answer sometimes, which is that depends. The answer is going to be different depending on if it is an owner versus a non-owner performing the landscaping. And our answer may also depend on how the person is injured. For example, there is such a thing as a concealed hazard. And if the injury is resulting from a known concealed hazard on the premises, on the property, that would entail a very different analysis than if a person got injured, cut themselves, for example, using a tool of their own on the property. So without additional specifics, and we're not here to give that kind of legal advice, to answer the question more generally, I would say that a non-owner, i.e. a non-resident, because I will later clarify that you may have someone who is a non-owner, but is, for example, a renter. So in this case, if they are a non-owner, a non-resident, a non-renter, performing landscaping work without being asked to under any specific contract or agreement with the board, with the community, to do work on the property, they would most likely be considered a trespasser under state law. So if you're looking at, and when it comes to trespass, there are very specific types of trespass. We're not going to get into all the details about trespassing, but there is liability associated with trespass for the person who is trespassing. And without specifics, that's something you just would want to be aware of. There are typically insurance provisions of your agreement with the carrier that may also apply. So you will certainly want to confer with your association attorney and your insurance carrier if there is an injury that occurs on your property by a non-owner, non-resident trespasser. Now, on the other side, if you have an owner performing landscaping work on common property that is not specifically their own property, obviously, this is less likely and most likely unlikely to be considered a trespass under state law, since they have the right to be present on condo property. That being said, their actions would be most likely considered a violation of your rules and regulations if applicable here, and of any insurance provisions of their own insurance agreement with the carrier. So there are some potential, what I would call gray areas here. We can't get into all the specifics. There could be all kinds of reasons why or why not this might happen. For example, an owner was performing work that was required for their personal safety, clearing brush that's blocking their driveway view. There's any number of reasons why a person might do this that aren't necessarily in contravention of the rules and regulations, but would still be a risk to the association. So again, you'll definitely want to confer with your association attorney and your insurance provider if there is an injury that occurs on the premises that affects an owner. That they were on common property that affected an owner that is in your community. I said earlier, I just want to reemphasize here that a resident renter that might not be an owner would still most likely hold the same responsibility as an owner and stand in the shoes of an owner in this instance. So if you have a renter that got injured on community property doing landscaping work that wasn't authorized, they would be treated most likely the same way that an owner would. And my last statement here would be just to emphasize one more time, if an injury occurs on community property, whether it is an owner that's injured, a non-owner, a trespasser, any of the above, you certainly want to alert your insurance carrier immediately and consult your association attorney to address any liabilities, questions, concerns that would come as a result of that injury. Ken, did you want to add anything?
Yeah, I would say for the most part, if you are concerned about liability, you should be looking at how your insurance is going to protect the association. You are required under UKIOA to have general liability insurance for your association. Um, it would protect you from claims for injuries in almost all cases. And you can certainly talk to your insurance carrier to find out how broad that is and if they thought there was going to be some kind of an exclusion for a person who was doing landscaping without permission. I don't think there will be an exclusion for it, but I'm not the insurance carrier. If you do have an injury, you definitely want to notify your insurance carrier. You don't have to file a claim, especially if you don't know if there's going to be a claim, but you do want to inform them of notice of circumstances that could lead to a claim. So if you knew somebody fell into a ditch and they were obviously hurt, you would want to make sure that the carrier knew, because some insurance carriers will want to reach out to the injured person and help them with medical treatment in order to avoid a larger claim later. So you're essentially giving notice to the insurance company of the events and circumstances so that they can manage the risk for you. And that's the end of our questions we had in advance. Chelsea, were there questions in the chat?
Yes. First chat question, archives. Are there specific requirements for what must be saved? What must be accessible to owners, in parentheses, minutes, budgets, how many years, etc. We are starting to develop rules, costs for meeting with owners. All records are kept by the secretary, no meeting space. Our meetings are held at city community space. We meet with folks at our library, charge by time, if not quick lookups.
Well, I'll take that and say this is one section where UKIOA and the other statutes do have very specific, detailed instructions on what records you must keep and how long you must keep them and what rights individual owners have to review those records. I believe it's 6490-495, or if you're a condominium, it's 6434-372. And it's a checklist. You can just go through and read the list. The only thing that is missing from that list, which I would usually include as defining them not as records, is emails, because the statute does not address emails between board members, between the board members and their management companies. It just is silent about emails. And we generally take the position that emails are not association records because the statute ignores them, and also because any action taken by the association has to be done in a board meeting, and that is the record of the action taken. The emails that might be sent in advance of that action are not relevant to the actual decision made at a board meeting and reflected in the board meeting minutes. So, you want to add anything, Tima?
No.
All right. RE proxy voting. Is there such a thing as irrevocable proxy?
Well, I would say no. The owner always can write a new proxy or assign a different person, and the owner can always take back the right to vote for themselves. You got a
All
different
right.
opinion, Tima?
No. Yeah, I mean, the proxy is decided per vote. So I guess you could change your mind and have a different person be your proxy at any given moment or time. So I don't know that you could have an irrevocable proxy. That I've never heard of it.
All right. Question about the collection process. How many days need to pass after the first delinquent letter is sent before sending the second letter? Then how many days pass between second and third letter, intent to lien? Then how many days pass after sending intent to lien letter? Can the HOA send to C or send to collections?
Okay. I see this one. Well, I guess there's a bunch of questions here. So I want to clarify whether you're asking about the statutory notice of delinquency, pre-foreclosure notice of delinquency that is required as part of the pre-foreclosure process, or your association specific delinquency notices, which are not the same thing, although related. So I'll answer it the best way that I can, which is number one, I would consult your governing documents if you have a collection policy, which we hope you do. If you don't, we highly recommend that you adopt one. Your collection policy would probably address exactly how many late notices are required before sending an account to collections. That said, as part of the pre-foreclosure process, you must send 2 statutory notices of delinquency to an owner before that. That's part of many aspects of the pre-foreclosure process. So I'm not going to get into the whole process, but just as far as what's required, statutory notice of delinquency, 2 must be sent. The first and the second can be no less than 60 days apart, and the second after the first notice is mailed, you must wait at least 60 days, and then after that 60 days has passed, you must mail the second notice of delinquency and wait 30 days from that ending point before you can initiate a foreclosure lawsuit, assuming all of the other pre-foreclosure requisites are met. As far as collections that begin on or about January 1st of 2026, we've discussed in our Q&A, and there are plenty of past recorded sessions that elaborate on the requirements for collections that have gone into effect this January. And there are requirements as to what must be included in your delinquency notice. I'm talking about your association-specific delinquency notice for each owner prior to that also must include a statutory notice of delinquency and the exact specifics of what requirements must be met before you can add certain late fees, before you can add any administrative or other collection related fees to an owner's ledger. There's that might be what you're getting at here, but just to answer the question about the delinquency notices, if you're talking about the statutory delinquency, there are 2 required, 60 days apart, 30 days apart, and you must be sending owners delinquency notices depending on what's required in your governing documents. We certainly recommend at least typically they're sent monthly. But again, that will depend on what's required in your governing documents. If it's required to be more or less than one.
So Tima, my understanding is that there's a requirement to send a notice within 30 days of a missed payment with a pre-foreclosure notice, and that if you don't send that, you are restricted in what administrative fees and late fees you can assess to an owner.
Those are the requirements that I mentioned that start January 1st, 2026. And we can go into more detail on that, but that's something we've addressed many times here before.
So if an association doesn't send the notice, then they just can't assess late fees and administrative fees.
Well, again, these are new laws, so I will say how we handle it. Yes, Ken, that's correct. Anything up until essentially the very end of January, the end of 2025, December 31st, 2025, up until then, no matter when the delinquency started, you can include your typical authorized late fees, administrative fees. Anything after January 1 of 2026 until you send the notice to the owner, which includes that pre-foreclosure notice that I mentioned, and specific language that must be included in that delinquency notice, you are restricted to 5% or $50 of the late fee, and you may not charge. You can't. There's a very specific restriction on what types of late fees can be assessed or punitive fees during that period until that notice expires. Once that notice expires, then we can go back to adding in your authorized late fees that are in your governing documents. So yes, I would call it a wait period. So for example, if you have waited until now, it's July, and your delinquency started back in January, all those months between January and now, we can't be charged unless if you haven't sent that notice and followed those requirements, you are restricted in what can and cannot be charged to an owner in terms of late fees, interest, etc., until that letter has been sent and expired. Once that's expired, then we can start adding those fees back to the ledger.
Okay, so another part of the question was about a document that was referred to as an intent to lien. Now, I don't think there's any requirement in any of the statutes to send a intent to lien. Is there any restriction on the right of an association to record a lien related to a delinquency?
Do you mean during that period of time before they've sent the delinquency notice?
Well, either before that notice or after that notice.
Well, they can't add any fees to the ledger that aren't, unless in anything related to collection until after they've sent the delinquency notice. So an intent to lien letter is not something that's mentioned in the statute. I think that it's something that's specific to a particular, if you have an intent to lien requirement in your collection policy or in your governing documents, that would certainly still be required. The statute basically establishes certain requirements. Your governing documents are free to make them more strict, but they can't be less strict than what the statute requires.
And could you briefly discuss the statutory lien that comes from the Condo Act and from UCIOA without any additional lien being recorded?
Well, yeah. So the associations under WUCIOA and under the other community, statutes have what's called a statutory lien. So that's essentially a protection that is in place as part of the statutory. It protects the association under the statute. That doesn't mean that we don't recommend that you record a lien with the county to put, by recording lien with the county, you are making that lien a public record. So that alerts other lien holders as well as obviously the owner themselves that there is a lien on the property. Is that what you're getting at, Ken, or did you have a different aspect?
No, I think that's right. There is a lien by recording something like a condominium declaration. It creates a lien against the unit for unpaid dues. And that lien exists even if you don't record a separate document stating the amount of the money owed. And so there actually have, I think, been a couple of appellate cases where no separate lien was recorded, and the courts have upheld the right to foreclose based on the statutory lien that was in the original governing documents. I think the primary purpose of recording a lien is to make a public record of a cloud on the title so that you don't have the potential for a transfer of the property without the association getting paid. Because if there's not a recorded lien to state how much money is owed, then the the purchasers would not know that that debt exists.
It certainly makes it difficult. And having recently been in a situation where actually we were referred a file about a week before the well, we didn't know the property wasn't listed for sale. We didn't know that, and the client didn't know that either. And we recorded a lien, sent a demand letter to the owner, and only to find out 2 weeks later that the day after we recorded the lien, the property was sold to a third party. Um, and there was a title insurance on it. That's what it's for. We ended up, it took some time, but we were able to recover that money in entirety for our client. And had we not recorded that lien, it would have made it more difficult for us, certainly, to to show our cause to the title company. But once, it was clear that it had been recorded, the title company missed it when they were doing their due diligence. So, in any case, there is no requirement in the statute to inform an owner of an intent to lien. There is a statutory lien on under the statute. Recording a lien with the county is simply a recommendation that we make in most cases when the threshold, when the balance is high enough to justify the cost of recording a lien, because there is a cost associated with recording and releasing a lien, and it does put, like Ken and I have both said, it's a public notice.
Okay, thank you. Chelsea, do you have other questions?
Yep. Our county is widening a street alongside one of our borders using eminent domain. They've offered compensation that pays the current fence and landscaping. Then they treat the land as undeveloped and offered a lowball compensation. RCW 6490 characterizing condo land as unique property type, beyond seeking an ED attorney. Any comment?
Well, this is way too specific for us to address in this forum.
All right. Are there limits on the questions a lender may ask from a condo HOA? We have noticed a significant expansion in multiple follow-up questions from lenders lately. A quick example is a specific follow-up question about insurance after COI was provided, then answered by the insurance agent quoting from the policy in a second follow-up, requesting a copy of the whole policy so they can verify. This requires approval from the board to be released. This is a small example of what we're seeing.
So there is a fairly significant change at the Fannie Mae, Freddie Mac secondary mortgage market level. I think we mentioned either last week or the week before that there is a new letter from Fannie Mae that is addressing property insurance requirements and funding of reserves. And so it's possible that these questions are related to those new requirements, which officially take effect on August 3rd, so a couple weeks away. Is there a limit to what a bank can ask? I would say no, there's not a limit to what a bank can ask. Is there a requirement for an association to answer? I'm actually not aware of any statutory requirement that the association respond to questions asked by banks. There's requirements that you answer questions asked by owners. And for the most part, associations are interested in their units being easily mortgaged and refinanced. So they are willing to answer questions for the banks because it does help the value of the units. We've seen a number of clients, and I think most management companies will have a fee for responding to the lender's questions. And I don't know if that's something that would help dissuade a bank from asking too many questions. But my guess would be that the insurance issue is tied to the bank trying to confirm that the property which they are loaning money on will be rebuilt if something happens to it, like a fire, and that their security is intact and or insured. So I guess to some extent the question is, well, are you answering questions for a bank, or are you answering questions for an owner or for a future owner? And what you have to do, I suppose if you really didn't want to answer questions, you could require that the selling owner make the records request. You'd still have to provide the entire insurance policy to the selling owner, who in turn would then provide it to the buying or the purchasing person's bank. So I'm not sure how to best balance the inconvenience against the benefit of providing information to the banks, but I do know that there is a significant change in the underwriting requirements in the banking industry going into effect right now. Do you know anything about that, Tina?
I don't.
Chelsea?
All right. So this one's a little long. Our association has a contract with a professional management company. The contract has a provision that provides for a designated board liaison to communicate and provide instructions to management between board meetings. The board unanimously approved a board resolution designating the president as board liaison with management, except for the secretary on corporate matters such as books, records, agendas, notices, and treasurer on financial statements, payments, etc. Some board members think that the liaison provision does not apply to them since they are officers. A vice president says that neither the management agreement liaison provision nor the board liaison resolution applies to him since he has powers under the bylaws to act as president if the president is absent or unable to do so. Should the board resolution be adhered to by board members and officers, does designating a board liaison violate powers of the vice president?
So I think this is also too specific a question for us to answer. I'll make a couple general comments. One is that the contracts between a management company and an association are a different set of rules and requirements than may be contained within the statutes. And I'd say it's not an unreasonable thing for a manager want to know who is speaking for the board. I'll say legal fiction is that the person speaking for the board is only doing so at the direction of the full board, and that they are sharing all of their information with the full board. So in real life, I'm sure that doesn't happen quite the same way, but it should be that any communication coming from the manager is available to all of the board members. And it should be that a request going to the manager for something specific should actually be a request coming from the full board following a motion at an open meeting. I don't know how you practically run associations and take care of minor problems without bending those rules at least a little bit. So, team, I don't know if you've got thoughts on this.
I agree with what Ken's saying here. I think, it's very specific, so I'm trying to just be general in my answer here. Obviously, you want to remember that if there's a decision to be made, all of those decisions need to be made in open board meetings. So we're talking about ministerial acts here, and essentially, I think that as long as, and you've said here that the board unanimously approved designating the president as the board liaison. So I guess I'm confused as to why now some of the board members are now not acting in compliance with that. So again, I think the best thing to remember is that, there does have to be when you have a management company, there does need to be some practical and effective way of communicating what's conveyed to the manager, to the entire board. And we I hope that your manager is sharing any questions or comments that come to the entire board. So there's no way for us to know more than that the way the question's been asked. Are there any more?
There's a comment on one of the previous questions. My lender insurance example was a simple example. Other follow-up questions include copies of correspondence with owners, repaired documents beyond the reserve study, and miscellaneous historical data. A fee is charged, but the time to provide has tripled. It seems the questions are AI generated due to specificity.
Well, I can offer that if you look up the lender letter from Fannie Mae, and it's entitled Lender Letter, parentheses, LL-2026-03, end parentheses, that you will get a copy of a 9-page letter from Fannie Mae, which is detailing the changes for insurance and for project standards. And this is all tied back to the Surfside condominium collapse in Florida just over 5 years ago, where the new requirements do say that the bank has to confirm that there are not any repairs that are a structural threat to the building. And so I can imagine that if you had a project such as a reclad of the building, or if you had wind-driven rain claims that were asserting that there was significant damage to the building, that the bank would want to have proof that the repairs had actually been completed before they provide a loan for a purchaser. But if you look up that document, you can have direct from Fannie Mae what their requirements are. I've seen a number of AI generated summaries of it, which have errors in them. So that's why I recommend you go straight to the original document from the government agency. Any others, Chelsea, or are we done for today?
Nope, that's it.
All right. Well, thank you, everybody, and
Thank you.
see you next week.
Stay cool, everyone.